Hello, my friends, and welcome to the Personal Responsibility Lawyer Podcast. I am your host, Michael Lovins of the law firm Lovins Trosclair, where we are personal injury lawyers, and we help people who have suffered terrible tragedies. I hope you don't ever need us, but if you do, please call us. You can reach us at 512-HURT-BAD. That is a number that has never been on this show before, but it's actually easy to remember, 512-HURT-BAD. For the first time in the history of this program, the fact that I am a personal injury lawyer actually has something to do with what we're going to talk about. And what we're going to talk about is tort reform. Now, a lot of times people's eyes may glaze over when they hear tort reform because they're not sure what a tort is, and reform just means change, and so that sounds boring. And then it starts getting into, well, something about insurance and something about jury trials, and it's not really all that interesting. But this is actually, I think, an extremely important topic. So now let me back up and tell you a little bit about me and in my last few months of life since I have done an episode of this program, which it's been a while. In the meantime, I rather unexpectedly ran for office. I ran for Travis County Judge, which for those of you not in Texas, county judge in this particular case isn't a judge that would sit in a court and hear cases with plaintiffs and defendants or criminals and so forth. It's more like county mayor, but we call it county judge. Why? Because we can. That's not the point. But I ran in Travis County. For those of you, again, not in Travis County, you've probably heard a little bit about us. Austin is the main city that dominates Travis County, and we're one of these incredibly nutty places that actually elects socialists to our city council. We have in the city of Austin a major socialist problem. It's not isolated to Austin. You hear about other places around the country, and in fact, a major presidential Democratic primary candidate is openly a socialist. We have a handful of people in the U.S. Congress who are openly socialists. It's not just Republicans saying, oh, that's a socialist thing. They actually say, we're socialists. That still stuns me. I don't know if I'll ever get over the notion of that being just crazy. So now, how does that have anything to do with tort reform? Well, let me explain. My Republican friends, who claim to be conservative, control the Texas legislature. They're only in session about 6 months every 2 years. We happen to be in one of those sessions right now. And as is frequently the case, the tort reformers come out to work their mischief on the state of Texas. They are out in force now, and their biggest vehicle this year is what's known as House Bill 19. A week ago today, from the time that I'm recording this, I went and testified against this bill. And there were a lot of people that testified against it. And there were a lot of very good and persuasive testimonies. But very little of the focus was on the principles that underlie the bill. We'll get in a little bit to specifically what the bill does, but the thing that drives me most nuts about this bill is that it is a major gift to the socialists. How so? Why would Republicans pass a bill that the socialists would like? Well, that's not what I mean. The socialists would not like this bill, except that they can use it as fodder to attack the Republicans and say, see what capitalists really are? They're crony capitalists. They're voting just in the legislature. They're just voting to protect their friends and their campaign contributors, their cronies, and they're voting against the interests of just a regular guy who didn't do anything wrong. The problem here is they're right. That's exactly what this bill is. It is crony capitalism on steroids. So let's talk a little bit about what House Bill 19 does. So House Bill 19 deals with wrecks involving commercial vehicles. I'm going to set aside the fact that this whole definition of commercial vehicles as it's currently written is a little nebulous. There's apparently a new version of this bill coming out tomorrow as of when I'm recording this episode. I don't know exactly what it's going to say. I don't know if they're going to fix that definition or not. That's not the point. You can kind of figure out roughly what they mean by commercial vehicle. The problem, I'm making air quotes. Can you see me making air quotes? The problem that they're trying to address is that there are too many large jury verdicts against trucking companies for killing and maiming people. So is that actually a problem? If it is a problem, what do we actually do about it? So is it a problem? Yeah. In some ways, yes. In some ways, no. Not in the way that they present it as a problem. The problem that the proponents of HB 19 have is that trucking companies kill and or maim somebody, leave them permanently disabled, lives absolutely destroyed. And the trucking companies, or really more accurately, the insurance companies for the trucking companies, don't like it that juries say, that's a really terrible thing, and we think to the extent money can figure out how to compensate people for that, it's a really, really large number. Now, I suppose you can argue that lives are worth less than what 12 impartial people say. But let's look at the principles that underlie this, because what I've been talking about are the interests. And if you have legislation that is based on interests, you essentially descend into what is just mob rule or some sophisticated version of mob rule. Or if you get really lucky, you have the arguably somewhat less benign, which is rule by the largest donors to political campaigns. I mean, that's the reality of what this turns out to be. But interest-based legislation is not what a conservative should advocate. A conservative advocates principle-based legislation. So what are the principles that underlie House Bill 19? And I'm looking at it from the perspective of what is House Bill 19 actually doing? The only thing that I can identify that even remotely represents a principle that would support House Bill 19 would be that this bill is pro-business. And it is, in fact, pro-business. It strongly favors the trucking companies and the insurance companies. And you hear a lot from Republicans who claim to be conservative that they are pro-business. And every time I hear that, I want to stand up and say, I object. I strenuously object. Because a conservative is not supposed to be pro-business. You're pro-free market. Because if you're pro-business, you're choosing the interests of the businesses over the interests of the consumers. Why? What's the principle that says the government should be picking the interests of the business over the interests of the consumers? No, we should have a principle that says this is the way that we conduct a fair, free market. And the interests here the principles here is that we should be in favor of a free market. Now, let's talk about a little bit about the free market. The free market is a double-edged sword. On one edge of that sword, everybody gets to reap the rewards of the good that they do for society. I'm not talking about the good they do for society like serving at a soup kitchen or serving the poor or something like that. Maybe you get paid to do that, but I'm not talking about charitable works. I'm talking about producing something of economic value and putting it out into the economy for people to buy, to pay for. If you produce something of value, you can sell it and you can reap the rewards. That is one side of the sword of the free market, and it is a beautiful, beautiful thing. But in order for that to work, you have to have the other side of the sword. That other edge is that everybody has to bear their own costs. So if I'm making widgets, I don't get to go sell the widgets for $5 a piece and keep the $5 and make somebody else pay the $3 that it cost me to make the widget. This is about as simple and basic as it gets. For a free market, you have to be able to reap the rewards, but also bear the costs. What is one of in a rather almost crass way of saying it, one of the costs of doing business for a trucking company is the fact that sometimes trucks kill and maim people. That's not something we should ever think of as, oh, well, it's just the cost of doing business. It's one of those things that any civilized society says that particular cost of doing business we need to bring dramatically down, as close to zero as possible. I will recognize that it's not going to be zero because we're humans, we're fallible, and people do dumb stuff, whether they even mean to or not. But who should bear the cost of doing that sometimes dumb, sometimes downright malevolent stuff that actually creates the costs that are borne by people who are just driving around, minding their own business, not doing anything wrong, and suddenly they wake up and their spouse is slumped dead over the steering wheel. That's a little stark, but that's actually what happened to one of my clients. Who should bear that cost? If you're a free market advocate, the trucking company has to bear that cost, and they have to bear it 100%. That is how the free market works, and it works that way because that's the only way to make things fair to everybody. You can't go imposing costs on other people without their consent. Now, there's a tricky issue here. What is the dollar value of the cost of somebody's life? And when I say life, I mean that in two different ways. One, the cost of somebody actually dying, and also the cost of somebody whose life is utterly destroyed. They're driving down the road, they're a healthy person, and then they get in a terrible wreck, and they are not healthy in a countless variety of ways that these wrecks affect people for the rest of their lives. And it's obviously never a good thing. How do you put a dollar value on that? Let's just agree that it's really, really difficult to do. Obviously, you can figure out the medical bills. You can figure out the lost income. Those are the relatively easy things. The things that are harder to figure out are, how much is that pain and suffering worth? How much is it worth in dollar figures to lose a spouse or to lose a child? That's a terribly difficult thing to put a dollar value on, but everybody knows intuitively that it is a major, major, major cost. It's not hard to put yourself in the shoes of someone who suffers that. So here's my contention of how a free market should work. You put that evidence on to a jury that has been vetted in what we in Texas would call voir dire. Around the rest of the country, they'd probably call it voir dire. It's just jury selection. You find 12 people, sometimes it's 6, depending on what court you're in, but you find these people who are impartial and are able to sit and hear the evidence and decide, we think that the dollar value of this loss, this cost that has been imposed upon these people, is X. Now, of course, I've jumped over one of the things that has to happen here, which is a determination by the jury of who caused the cost. Sometimes it's not the trucking company. Sometimes the truck driver did exactly what he's supposed to do, and the other driver did something wrong, in which case the proper free market principle is that the jury should say the cost has to be borne by the driver who's not the trucking company. They caused it. We're sorry, it's terrible. But that's the way it has to work. That's fair, that's free market, and that's the kind of thing that a principled conservative advocates for. My Republican friends who advocate for tort reform love to use phrases like runaway juries and jackpot justice and all of these things that essentially it just denigrates the work that a jury does. Again, we've already talked about them being impartial, or at least that's the idea. It's never perfect. Sometimes you get someone who's not impartial, and that cuts both ways. But again, getting back to a conservative principle is that the government shouldn't be deciding these things from on high. This should be decided as close to the local level as possible. A jury is as local as it gets here. I don't know of any principled reason why the legislature should come in not having heard the evidence presented to the jury, and say that jury was wrong? How do you know? Come in and sit and listen to the evidence and then decide. But don't sit here in the legislature and claim that you know based on not having heard the evidence. That's what evidence is for. Listen to it. Those aren't the only arguments that the tort reformers like to advance in support of their cause. I want to address I'm going to get to some arguments that I'm actually sympathetic to in a minute. But first I'm going to address some of their phony arguments. One of them, and I heard this at the hearing the other day, that plaintiffs' lawyers are using psychological tricks to manipulate the jury and make them scared. What? That's just gobbledygook. It doesn't even mean anything. First of all, every trial that I've taken part in, and that's several, there's actually a lawyer on the other side. I'm not the only one there getting to talk to the jury. These trucking companies pay their lawyers too. They're professionals. They take their job seriously. They do the very best they can. And what these people are complaining about is that some lawyers are really, really persuasive. That's not a psychological trick. That's persuading the jury. And if the trucking companies are mad because the plaintiff's lawyers are making juries think that trucking companies are dangerous, let me float this out here. Hey, maybe I'm crazy, but maybe the reason that juries think trucking companies are dangerous is that they're dealing with a case where a trucking company killed somebody. I don't know. I mean, maybe I'm talking crazy talk here, but maybe that's why. And maybe it's because in their own personal lives, they've driven up and down I-35 and they have been scared to death by some of the things 18-wheelers do on I-35 and other roads too. Maybe that has something to do with it. That doesn't mean every truck driver is unsafe. It doesn't mean every trucking company is unsafe. But it does mean people's own experience tells them, I'm a little bit afraid of these trucks sometimes. Okay, now let me take on another tort reform advocates love to talk about. It's two things that are kind of the same. Frivolous lawsuits and lawsuit abuse. Okay, I don't like frivolous lawsuits, but a lot of this is just such an incredible red herring. Think about this for just a second. Pretty much everyone knows that plaintiffs' personal injury lawyers work on a contingency fee, which means, because you've seen it on the TV commercials, which I hate, but they're there, whatever. We don't get paid until you get paid. That's how it works. Now, put that in the context of a frivolous lawsuit. If somebody comes to me with something that's just completely stupid, that's a frivolous lawsuit, do you think that I'm actually stupid enough to say, hey, I know this is stupid, let's file it anyway because I'm going to do a bunch of work and then lose? That's asinine. That's one of the dumbest things I've ever heard. But they throw it out there all the time with the idea that these plaintiffs' lawyers are just making tons of money filing frivolous lawsuits. It's so absurd that when I'm talking to my conservative friends, like if I go to lunch with them or something, I often say, well, I got to get back to filing my frivolous lawsuits, making all that money. It's absurd on its face. Now, I have seen frivolous things happen in the context of lawsuits. I've seen actual frivolous lawsuits because one of the other things that I do, most of my work is representing people who've been injured or they've lost a loved one. But I also do cases that are business litigation. On those cases, I get paid by the hour. And usually the guy on the other side or the woman on the other side is also getting paid by the hour. You want to see an incentive to do things that are frivolous, to make arguments that are just completely stupid, to file motions that you have absolutely no chance of winning or that are just completely stupid. If you have a lawyer who's being paid by the hour and they don't have a ton of integrity, that's a great incentive for them to do frivolous things. It happens. It's almost never happening by somebody who's working on a contingency fee. And if somebody working on contingency fee repeatedly files frivolous lawsuits, guess what's going to happen? The free market's going to step in, and that dude or that woman is going to go bankrupt because they can't make any money. This is obvious. Why is it not obvious to the other side of this argument? Well, it's obvious to them too. They have just spent the last 30 years throwing the term frivolous lawsuit around, and they've conditioned people to assume, without actually thinking through the issue, that all these plaintiffs' lawyers are just making a ton of money on frivolous lawsuits. It's poppycock. That's a technical legal term. You can look it up. So now that we've talked about this whole idea of frivolous lawsuits kind of being silly in the first place, I'll concede something that's possible. Something that, I'll go beyond it's just possible. This happens because humans are humans. Two things can happen. One, somebody can just completely make up the fact that they were in a wreck. That doesn't get you very far because it's usually pretty easy to prove, the wreck didn't happen. So as frivolous things go, that doesn't happen too much. I've actually never seen it. I've heard about it, and I'm not sure if those stories are true, but I'm sure somebody's lied about a wreck happening. The thing that is here's something that's I'm more sympathetic to, and that is somebody getting in a small wreck and exaggerating their injuries. It's hard to know when this happens, because how do you know if somebody's really in pain if you're not with them all the time or whatever? Sure, people are going to exaggerate their injuries in some small cases sometimes because there are dishonest people in the world. Big surprise. And that's one of the reasons that is put forth as why we need House Bill 19. But what they don't tell you is what in House Bill 19 does anything at all to fix that. And if you know anything about the practice of law as it pertains to personal injury cases, you'd look at House Bill 19 and say, well, I don't see anything in here that fixes that. Because it doesn't. So essentially what House Bill 19 does, and I know we haven't gotten into really any of the specifics. We're talking about tort reform generally here. I'll get into we'll descend into some legal nerdery on some specifics of what House Bill 19 will do. But for right now, if you look at House Bill 19, what it does as a general matter is it says, we don't like frivolous lawsuits, so we're going to make meritorious lawsuits smaller. Well, that's a stupid approach. I'm sorry, is that not very diplomatic? It's true, though. It's a stupid approach. It's not really addressing the problem. But here's what it does that's not stupid. That's not really the problem they're trying to address. The problem they're trying to address, and this gets back to something I've said before in this very episode, the problem they're trying to address is that juries who are hearing the evidence, who are looking at the plaintiffs and they're looking at the defendants and they're looking at what happened and they're looking at how the plaintiff have suffered, and they are saying, this is the dollar amount that we think is right. And the insurance companies and the trucking companies say, life isn't worth that much. Or maybe, to put a finer point on it, what they're actually saying is, we don't want to pay that much for the lives that we stole. That's what's really going on here. And House Bill 19 will be very effective at doing that. All right, so now that I've talked about how stupid most tort reform is, let's talk about the specifics of House Bill 19. So, first of all, and this is the biggest thing that it really does, it dramatically changes the story that the jury will hear when a case is presented to them. And it does so in a way that is specifically designed to get the jury to return a verdict that has a smaller dollar value on it. Now, I'm going to be very candid and say it's easy for plaintiffs' lawyers to say, I don't like this bill because it's going to make jury verdicts smaller. Well, again, that's getting back to, these are just people who are arguing from their own interests, but they're not arguing from principles. So let's talk about the principles that underlie my opposition to House Bill 19 and why it's a very anti-conservative bill. Let me start off by telling you briefly a story of a case that I actually handled within the last couple of years. I'm changing the name of the company and I'm changing the name of my client, I'm not going to mention the name of my client at all. I'm changing the name of the company and also the driver. We had a confidential settlement. Even if we hadn't, I'm not going to put actual names out there in this environment or in this setting. It doesn't do any good. You can take my word for it or not that this is actually what happened. Here's the story. Company XYZ hires a guy who we'll call Bob. couple weeks after they hire him, they give Bob a drug test. Bob fails. He's taking drugs. He's smoking pot. And it comes up in his drug test. They fire him. Good on the company. That's what they ought to do. This guy was driving their vans. He took drugs. That's not safe. Get rid of him. But about 2, maybe 3 weeks later, after they fire him, they hire him again. They hire him right back. This time they don't give him a drug test. Now, the work that Bob was doing is mostly late evening and at night. So Bob's normal pattern was that he'd get off work in the early hours of the morning, he'd sleep for a while, he'd get up, he'd play video games and smoke pot until it's time to go to work. You can kind of see where this is going, I suspect. So a couple months after being rehired, Bob's driving the company van out to a job site at the beginning of his shift. As you would expect, it's at the end of a day that he has spent playing video games and smoking pot. Now, in his inebriated state, he manages to navigate most of the way across town without any serious incident, and he finally gets to the road where this particular job site is located. It's a major road in Austin. If I mention the name, most everybody's going to know what it is. 3 lanes of traffic go in both directions, and there's a turn lane down the middle. To get into the parking lot, Bob has to take a left turn. He gets into the left-hand turn lane. He starts his left-hand turn to go into the parking lot. As he does, he sees a motorcycle coming right at him. He jerks the wheel to the left, trying to get out of the way, but it's too late. The young woman who is driving that motorcycle crashes into the passenger side of the van, and she dies. That's not the end of the story. Bob's supervisor is with him in a different vehicle, but they're all heading out to the job site together. The supervisor says, Bob, company policy says, we got to go get a drug test. Since you were driving and you got in a wreck, company policy, get a drug test. Let's go. So supervisor drives. Bob goes with him. It's 7:30, maybe 8 o'clock at night, something like that. They drive for a couple of hours around the city of Austin and then say, we can't find any place that can give us a drug test. Isn't that convenient? That's the story. We represented the parents of the young lady who was on the motorcycle. I can't imagine being in their shoes. So now let's talk about how HB 19 changes this case. If you're sitting on the jury, what do you want to hear in order to evaluate this case? Not just who's at fault, but then how should the parents be compensated for the loss of their daughter? House Bill 19 would not let you hear anything about the drugs. They wouldn't let you hear anything about the fact that he had tested positive, been fired, and then rehired. They wouldn't let you hear anything about the fact that they had not tested him again since he was rehired after having been fired. They don't want you to hear any of that. They know, and I know, they're right. I'll agree with them. Keeping that information out of the jury's knowledge will cause them to render a verdict that is a smaller dollar figure for what it means to lose that child. So again, let's go back to the theme that has come before here. Are we arguing from interests? Because if we're arguing from interests, the interest of the trial lawyers and the parents of this lost young woman are to get more money, and the interests of the trucking company and the insurance companies are to pay less money. I don't have any way to evaluate which of those interests is better. Whose interest should I vote for? So interests, that's a bad way to approach this. Let's look at it from principles. What is the purpose of the lawsuit against the company that killed this young woman? Well, there's a couple of reasons, and I'm not making this up. This is what's in the case law. One reason that you do this is to compensate the people who have suffered the loss. The other reason, and as someone who thinks of himself as a personal responsibility lawyer, to me, this is the biggest reason. The biggest reason is to make sure that we deter the kind of conduct that leads to a pot-smoking high driver of a company van to be let out on the roads. What is that conduct? Let's find it, and let's use free market principles, meaning impose the costs upon the one who actually did it, to deter that. When somebody has to bear their own costs, they really, really work to minimize those costs. So given that we are trying, with this lawsuit, we are trying to deter bad conduct. We're trying to impose responsibility on these actors. The jury needs to know which actors they're actually dealing with. Now, House Bill 19 wants them only to deal with this driver in this particular event. They basically want to start maybe 10, 15 seconds at the most before the wreck actually happens. But if you're trying to resolve this problem, say you're coming in as a risk manager and you're doing an after analysis and saying, how do we fix this? You're not going to go to Bob and say, okay, Bob, you got to just make better turns. You got to look better before you make a left-hand turn. You might do that, but if that's all you do, you're not doing anything. You've got to go back in time and say, okay, well, why was Bob allowed behind the truck, the wheel of this van while he's high? And then you find out, oh, well, he's allowed behind the wheel of this van while he's high because he was rehired after being fired for a positive drug test, and he wasn't ever given a drug test again. That's why it happened. So if we're looking for conduct to deter, and we are, we have to look at all of the conduct. This is a massive, massive change in the law. Now, the proponents of House Bill 19 are trying to tell you this is hardly any change at all. It's pretty much the same thing, just a little twist, a little turn, but no big deal. What this bill does is it says the jury only gets to evaluate the conduct of one tortfeasor. Tortfeasor is a dumb word. It means bad actor. It's not a dumb word. It's just overly legal. But in law, we use legal words, whatever. It's a tortfeasor. We have more than one tortfeasor. We have a company that the name of the cause of action is negligent hiring. There's another cause of action called negligent training, and then negligent supervision. All three of those things are present here. And the company is the one who did those things. And those things caused this wreck, just as much as Bob taking that bad left turn caused this wreck. This is a system. Our whole economy works in systems. It's not these little discrete events. And nobody who's trying to build a business looks at little discrete events. You look at the system. And the system failed. And the jury needs to know that so they can assess what happened. Let's talk a little bit further about this. And we're descending into legal nerdery here, but this is important to understand what your legislators, if you're in Texas, what your legislators are trying to do. So, in almost every case that I try, the defendant makes a claim of what's called comparative fault. Some places call it contributory negligence. So in the case that I've just told you about, the company said, well, we think the motorcycle driver was partially at fault because she was going too fast. Now, mind you, they had no evidence she was going too fast. They just said, saying this out loud, it's almost embarrassing that they made this argument. Bob, again, Bob who was high, thought when he saw her, she was going pretty fast. Okay, that's your best claim. All right, whatever. The law, at least in Texas, is that when a defense says, well, it's partially at least, or partially or completely, the plaintiff's fault, the jury's going to be asked to assess the level of fault. I'm going to try to explain this in a way that it's not too wonky. The jury is going to be asked, okay, which of the following people was negligent? And there's going to be a line for the motorcycle driver, negligent, yes or no. Bob, negligent, yes or no. And then XYZ company, negligent, yes or no. Then for anyone that the jury says, yes, they were negligent, then there's another question. And it says, okay, now you have to determine the percentage of fault for each of the ones that you said yes. So if the jury says, yes, motorcycle driver was negligent, Bob was negligent, and XYZ company was negligent, now you have to assess percentages for that, and they have to add up to 100%. So say motorcycle driver, they say, well, nobody's perfect. We're going to put 20% on her. Bob, he's the really bad guy. He's 50%, so that's 20 plus 50. That leaves us 30%. We're going to put 30% on the company. What House Bill 19 does is it says, no. We're going to only have 2 lines. The jury's only going to look at Bob and the motorcycle driver. Okay, so who cares? What difference does that make? It makes a ton of difference because, for one, the jury is not going to know under House Bill 19 that, like I mentioned before, they're not going to know that XYZ company just totally ignored the fact that Bob has a drug problem and they put him behind the wheel of their van. They're not going to know that. It's very normal to say, okay, well, we're going to say, we don't think motorcycle driver was perfect. Juries just don't like to let anyone be perfect, and that's understandable. That's a human response. They maybe could have done something better. If there are 3 lines to fill out for percentages, I'm sorry, we just went through 3 lines. If there's 2 lines to fill out as percentages, that tends to be something more like, 60-40. So 40% of the fault very possibly gets put on the motorcycle driver if the jury doesn't know how badly the company acted. Now, jump forward, the jury is then going to be instructed, okay, now we want you to put a dollar amount on the damages. What's the dollar figure for that the parents should be compensated? And there's some different categories of it. But then once that jury verdict comes back, what the judge does, and this is what is required, any percentage that is of negligence that's put on the plaintiff, in this case the motorcycle driver, that gets deducted from what the plaintiff gets to recover. So let's just say that the jury says, okay, the motorcycle driver was 40% at fault, and then they say the total damages are $1 million. Well, that 40% gets taken out. So now that $1 million gets cut down to $600,000. So you can see here how this works, where what's really going on here is the insurance companies and the trucking companies want to be excluded from this calculation because they know that's going to mean a smaller percentage, in most cases, gets put on the company's driver, and a larger percentage gets put on the plaintiff because the jury's not considering and not being allowed to even know, let alone consider, the bad conduct of the company. So this is a direct attack on reducing, without any principle to underlie it, reduce the amount that a life is worth. From the party that almost all of them say they're pro-life. So now let's turn to the purpose of tort law, personal injury. Torts aren't just personal injury, but that's what tort reform usually means. It's usually targeting personal injury suits. Not completely, but certainly for House Bill 19. If one of the purposes is to compensate the plaintiff, an argument that the tort reformers make that intuitively makes sense but is actually wrong when you actually know something is that, well, what difference does it make how badly the company acted? If someone's kid died, someone's kid died. And so you're just trying to make the jury mad at the company, and if the jury's mad at the company, they're going to try to punish them, and they're going to make it a bigger number. First of all, that's not entirely false. But why is it other than my interest in keeping jury verdicts from shrinking, what is the principle that I would argue against that and say, well, no, it's not the case that a lost child is a lost child is a lost child and it doesn't matter. I've had the unfortunate privilege of working with people who specialize in grief because I work with a lot of people who are going through unbelievable grief. And what I've learned from people who actually know about grief from a scientific perspective is that the manner in which they lose someone matters a ton. It's one thing. Now, let me preface it with this. All of these are absolutely horrific, but they're different levels of horrific. It's one thing for someone to lose a child, spouse, whatever, as a result of, for example, a disease that they just got for genetic reasons or reasons that just bad things happen. It's a horrible loss. Outside of my law practice, I have had people who have lost loved ones just due to disease. There's nothing to do to prevent it. There's just nothing you can do. That's a horrible grief. And as a parent, I don't know how the pain ever goes away. It's entirely different. Entirely might be a bit much. It's very different from someone who loses someone to, for example, murder. The malevolence, the complete and utter avoidability of the tragedy that ruined their life. That's a whole different kind of grief. So now let's put this into the personal injury context. It's one thing for someone who loses a spouse or a child or a parent as a result of Bob just making a bad turn. He just messed up. People sometimes just mess up. That's the reality. But when you know that there's this company out there that just didn't care, they would rather be able to hire Bob and pay him less. And when somebody dies, we'll just try to limit the damage. We'll try to get out of it for as little as we can. It's not quite malevolence, but it's really, really maddening when you know that you have suffered loss that was completely pointless and completely avoidable. That's a different kind of grief. It's a grief that's deeper, that has even more anger. It's incomprehensible to those of us who haven't actually suffered that, what it's actually like to go through that. But that's an important reason why the jury needs to know the whole truth about what happened, because they need to be able to compensate for the whole truth of what the plaintiff is suffering. That also goes not just for losing a loved one. That goes for if you're, for example, you're walking around living your life, you get in the car to go somewhere, and you wake up in the hospital and you're now a quadriplegic. And you have to live the rest of your life knowing that you are a quadriplegic because somebody just didn't bother enough to care to make sure that they operated a safe company. Can you imagine the constant anger that you'd have to fight? If the response from the tort reform advocates is, well, let's just not let them know. Why would you want to deepen their anger? And to that, I would say, all right, if you want to make it the official policy of the state of Texas that it's not important how badly somebody acts, it's better to hide it. Okay, you take that position. I'm not going to take that. I believe that the oath that is given that a witness has to take before they get on the stand applies to the whole process. We want the truth and the whole truth and nothing but the truth. That's why a jury needs to know the full truth in order to compensate for the full truth. HB 19 doesn't want that to happen. All right, a couple more things about HB 19 that are completely messed up. So now, okay, a very brief descent into legal nerdery. In the original version of the bill, there is what we would refer to as a Mandamus provision, which basically says if a trucking company gets a ruling on discovery, meaning the judge says you have to turn over the following documents and information to the plaintiff. If the trucking company gets that ruling and they don't like it, they can do what's called Mandamus, which essentially does this. It pushes pause on the entire proceeding, and they get to go up to the appellate court. And in Texas, we have 2 levels. They can conceivably go all the way up to the Supreme Court to get relief from that order that the judge made. They might win, they might lose. It doesn't matter because they always win in the following respect. They push pause on this thing for probably a minimum of a year. If they go all the way up to the Texas Supreme Court, that's very easily 2 years. That the whole thing just gets put on pause. Now, what does that do? It does several things. First of all, a lot of times, someone who's been injured in a severe way, they need medical care and they need it right now. And you know what they don't have for it? Money. And the longer they go that they have to go through this legal process, the longer they go without having the money that they need for the medical care, which is more suffering. And in a lot of cases, it just means the medical care is not going to be very useful later on, because when you wait too long, you lose the opportunity to heal. Medical science can only do so much. Now, the flabbergasting thing about this is that this is one of those one-way streets that if the plaintiff got a ruling that they didn't like, they don't get the right to have a mandamus and push pause on the whole thing. They have to go all the way through a trial, and if the result that they get at the trial is not a good result, then they have to appeal it. That increases the expense for the plaintiff enormously and makes the thing play out even longer before the plaintiff will see any money. Because even if they win in that first trial, if they're appealing something, they're not getting the money. So it's a one-way street. Now they've said, the chairman of the committee said that they're taking that out, which is an improvement. But the fact that they would put in such a one-way street that only favors trucking companies and insurance companies, what does that tell you about what they're really up to? They just want to be in favor of the trucking companies and insurance companies. I'm not against them, but I'm not going to make policy or advocate for policy that just helps one side while hurting the other based on nothing other than interest. There's no principle to support that kind of thing. All right. Final thing about stupid stuff that House Bill 19 does. That at first kind of looks intuitively, yeah, it makes sense. But I'm going to ask you to go down into some legal nerdery with me on this to understand why it's a terrible idea. It has a provision that says, okay, let's say we go through a jury trial. The jury says, yes, defendant, you were negligent, and you have to pay the plaintiff X dollars. How this works in practice is that the jury is asked the following question. What amount of money, if paid now in cash, would compensate the plaintiff for different categories in the future? Specifically, one of the main things is medical care or loss of income in the future. Now, past is a different thing. What HB 19 says is that anything that's awarded for the future, the defendant can opt to pay in the future. Okay, well this is the part that intuitively you kind of think, okay, well, that makes sense. I mean, they're not going to incur the medical costs or the loss of income or something, or that sort of thing. They're not going to incur it now. They're going to incur it later. So let's let the defendant pay it later. But we're going to get into math nerdery too a little bit. It's the jury's told to decide what amount of money if paid now in cash. So let's assume that it's going to cost $100,000 a year for the next 10 years for medical care. Now, I've handled some of these things where that can sound like a lot. Who has $100,000 of medical care? Well, somebody who has been severely and permanently injured. That's who. So it's already been determined by the jury that they're going to need medical care in the future, and it's the defendant's responsibility to pay for it. $100,000 a year for the next 10 years. That sounds like $1 million, right? Well, no, because net present value, and this is another thing we have to do as plaintiffs, we have to then get an economist to say, well, okay, so she needs $100,000 every year for the next 10 years. If you do all kinds of math mumbo jumbo and reduce that to net present value, I just used a website and used a discount rate of 3%, which is probably pretty low. That $1 million or $100,000 a year, that turns out to be only $853,000. So that's almost $150,000 less than the full amount. Now, under the current law, without HB 19, the defendant has to pay $853,000 for that $1 million of future care. But under HB 19, they get to break that down and pay it out over the future. But the jury verdict doesn't say $100,000 a year. It says $853,000. So what the defendant presumably is going to get to do is they say, we're going to divide this $853,000 up over 10 years, and so we're going to pay $85,000 a year. Well, I'm no mathematician, but it looks to me like the plaintiff is getting shorted $15,000 a year. Why on earth would you do that? Now let's go back. Okay, here's the interest. And we're using principal and interest in ways that is a little different than normal, because usually we're talking about paying off our mortgage or something, and we've got to pay off the principal and the interest. A little different here, but I think you can follow. The interest here is that the insurance companies get to hold on to their money longer, and they make money on doing that. And often these insurance companies have annuity life insurance companies, and they sell themselves an annuity in order to pay these future damages if they get the benefits of House Bill 19. So it's a bonanza for the insurance company, but it's a penalty to the injured or the family of the killed person. How do you justify that? In what world does that make any sense? The only world in which that makes any sense is the one in which you're trying to help trucking companies and insurance companies at the expense of the people they injure. Here's the other huge problem with this. Future medical care is really hard to predict the timing. So let's go back to the scenario where we say, okay, they're going to need $100,000 a year for 10 years. That's not necessarily going to be an even $100,000. There may be some major surgery that has to occur in sometime in the future, but say it's a back surgery, and at the time of trial, the doctors say, well, you could have the surgery now, but we'd rather wait until you can't bear the pain anymore. That's not an uncommon thing to happen for surgeries of any sort. So if the insurance company is getting to pay this out over time, and they're paying $100,000 a year, and it's expected that this surgery is going to be needed in, say, the 5th year, but the pain becomes unbearable in the 3rd year, what are they to do? Because they're not getting paid for that surgery until the 5th year. They don't have the money for it, but they need the surgery. First of all, why would you punish the injured plaintiff who did nothing to bring this upon themselves? Second, the reality of what's probably going to happen is they're going to have to get on Medicare or Medicaid. And so we're all going to end up paying for that surgery when there's an insurance company who owes the money. They just got some legislators to pass a law to help them avoid responsibility. And again, this flies in the face of conservative principles, because one of the main things that as conservative free market advocates we believe in is private property rights. When someone has a jury verdict rendered in their favor, that is a private property right. That is a piece of private property to which the plaintiff has rights. But here you have the Republicans who want to come in and say, no, we don't like that private property because not liking it can help the trucking companies and insurance companies. That's just the harsh reality of what this bill does. Now let me hit one more way that this provision of letting the insurance company pay out future damages in the future is anti-conservative. One of the things that conservatives believe in fact, the whole reason that I call this podcast The Personal Responsibility Lawyer, is that we expect people to take responsibility for their lives and for their choices. One of the underlying justifications for this part of HB 19 of paying out future damages in the future is that the plaintiffs can't be trusted to actually use the money for their health care or for their income. They're probably just going to go blow it and not have it anymore. Well, that's possible. It can happen, and undoubtedly it has happened before. But since when, as conservatives, do we assume that somebody's going to be stupid? Aren't we supposed to trust people to make their own decisions for their own lives instead of having the government step in and make it difficult for them and take those decisions away from them? That's one of the least conservative things I can think of. All right, I've gone into a bunch of the reasons why I think House Bill 19 is a complete disaster. I want to be fair to the people who proposed this bill. And at the hearing in the committee on this bill, there were several people from trucking companies, mostly small trucking companies, who voiced their complaints about the current situation that they're faced with. And I don't want to overlook those because I think they had some very legitimate complaints, or at least things that sounded like legitimate complaints. As a free market conservative Republican plaintiff's personal injury trial lawyer, I'm not in a position to evaluate just how true they are, but I'm going to assume that they're true because I have no reason to think that they're not. Here's the biggest complaint that I heard that sounded legitimate, and that is trucking companies who have had no wrecks are seeing their insurance go up double or more. No wrecks, insurance rates skyrocketing. Now, the part of this that I find dubious is they say it's because of all these huge jury verdicts. I'm very skeptical. One kind of side note, I carry malpractice insurance because I'm not stupid. I have never had a claim made against me. I've never had anything. And my rates are also going up very high. So why isn't anyone looking out for me? I don't think I need someone to look out for me, at least not by some legal malpractice tort reform. I say that only to say it's not limited to trucking companies. So to draw the line, the supposed line from jury verdicts against trucking companies to increasing insurance premiums for trucking companies that don't have those jury verdicts, it seems to me there's not the evidence to support that. But I could be wrong. And I mean that sincerely. Maybe I'm wrong. The problem with HB 19 is it doesn't fix that. Or at least to the extent it fixes it, it does so by saying, well, we see insurance costs rising for safe trucking companies, so we're going to lighten the load on unsafe trucking companies. We're going to shift the costs that are imposed upon society by unsafe trucking companies onto the ones that they injure. In what world does that make sense? And certainly in what world does that follow any sort of conservative principle? It doesn't. If this is a problem, and I'm willing to agree at least for now that it is a problem, that their rates are going up, maybe we should look at insurance companies. Maybe the regulation to fix this needs to target insurance companies. But you don't ever hear these tort reform people saying, let's regulate insurance companies so that their premiums don't go up so high. I wonder why. I'll tell you why. It's because the tort reform movement is largely dominated and funded by insurance companies. There's one other complaint that I heard at the committee hearing that I think is something that needs to be addressed, and that is there are truck drivers who have experienced what they call targeting, which is where some other non-truck driver tries to essentially bait them into a wreck, thinking that if they just get into a wreck, they're going to get a bunch of money. Now, if you think that's a good idea, you are incredibly misled, because if you get into a wreck, first of all, say you bait some truck driver somehow to do something negligent, and you get injured enough to get a large settlement or jury recovery. That means you are horribly, horribly injured, and it's never, ever worth it. No one in their right mind ever gets a huge dollar figure and says, well, I can't walk, but at least I got all this money. So But that doesn't mean nobody does that, because there are these people out there who are, they're greedy and not necessarily thinking through what they need to think through. So what do we do about this problem? I don't know exactly, but here's one thing that I'll float out there. A lot of these the trucks, they have videos in their cabs. So if they catch somebody on video doing this, and a lot of times the license number is visible, if they have the proof on video, let's have a way that they can send it into the Department of Motor Vehicles or Texas Department of Transportation or something like that, and actually impose some consequences on the moron who's doing this and risking not only his or her own life, but the lives of people all around them. It's a terrible thing for someone to do. And if it's a persistent problem, and I'm willing to at least hypothesize that it's true, let's fix that. House Bill 19 doesn't fix that. House Bill 19 essentially says, well, there are cases that people try to target trucking companies on. And so in order to stop that, we're going to make the real cases harder for the plaintiff to recover. And we're going to shift the costs of that onto the injured people who didn't do anything wrong and away from the trucking companies who did. All right, let's start bringing this thing into a landing. I started this whole thing off by talking about how we have a socialism problem, and we do. If I were a socialist, I would look at HB 19 and I would say, see, I told you so. When they say that everybody's supposed to be responsible for themselves, they're supposed to, they say they believe in a free market and all this stuff. They don't. It's crony capitalism. They're voting for the insurance companies and the trucking companies because they gave them a bunch of money. And then what real capitalism is where you rig it in favor of the rich and the powerful and against the little guy. If I were a socialist, I would point at HB 19 and I would say, see, this is evidence that they mean responsibility for thee, but not for me. As conservatives, we teach that people should bear the consequences of their own actions, whether that's good or bad. But contrary to the free market principles, HB 19 makes it easier for the bad actors to avoid the consequences of their actions. Again, if I were a socialist, which is a little, in my opinion, like saying if I were the devil, I'd point to HB 19 as hypocrisy, typical hypocrisy from so-called capitalists who preach about taking responsibility for your actions, but they pass laws so that they and their rich friends don't have to take responsibility for their actions. If you want to make socialism look good, set it up next to crony capitalism. And suddenly, socialism looks a whole lot more attractive than it would if it were put up next to true free market capitalism. So you might say, I'm on a little crusade here to fight for conservative principles, and by fighting for conservative principles, I have to say HB 19 cannot pass. It is anti-conservative, and it opens us up to even more socialism running amok in our country. For Levins Trosclair and the Personal Responsibility Lawyer podcast, I am Michael Levins. I can't complain, but sometimes I still do.